John Belcher, law offices of John Belcher. One thing that they don't teach in graduate school is how to manage litigation. Obviously, the reason people didn't go to law school was they didn't want to be lawyers. But managing litigation and managing an attorney once you've hired them is very important. And in order to prevail in a case, an attorney is going to have familiarity in 10 different areas. And the client is going to have to test to make sure that once they've hired an attorney, as the case progresses, the attorney has these 10 areas down. 1, your attorney needs to be thoroughly familiar with the case, as familiar as you are, and understand the client's desired outcome. If the attorney doesn't, how do they have a path to victory as you see it if they don't know what that is? 2, the attorney should understand the applicable rules of evidence. I was brought in on appeal on a case that was a $21 million loss for an attorney out in the Inland Empire. And the opposing counsel told me that this attorney let in an agreement between the husband and the wife that they did not have authentication on. In order to develop skills and understand the rules of evidence, you need to have a lot of active court experience. 3, the attorney should have a clear understanding of the client's testimony. That would include all the discovery responses and all of the deposition testimony and all of the background of what the client has to say. 4, the attorney should be prepared to anticipate and refute potential impeachment evidence. This means that the attorney has a thorough grasp of how and where the testimony is going to be attacked. 5, the attorney should have a solid grasp of the opposing party's case. It's not enough just to know your story, you need to know their story. 6, the attorney should be prepared to effectively cross-examine opposing witnesses, in particular, the principles of the opponent. That is what the jury and judge are looking for. They are looking for the moment of truth when the cross-examination is there between the lead plaintiff's attorney and the defendant. 7, the attorney should be familiar with the use of demonstrative evidence. Timelines, charts, ways to organize and make simple the story are extremely effective tools, and an attorney that's going to be effective should have the ability to do those and should have them ready well in advance of trial. 8, the attorney should be prepared to make opening and closing statements. It shouldn't be off the cuff, and the client ought to be satisfied that the attorney is going to be doing a good job, particularly in opening, because a very large number of jurors make up their minds very early in the case, including after opening statement. 9, the attorney should be familiar with the use of technology in the courtroom. Some trials are actually being conducted remotely, and an attorney should be at the height of technology in not only understanding but usage. And 10, the attorney should be prepared to deal with the opposing counsel's objections. That means really understanding the evidence code and knowing how to get your evidence in. These are all things that you want from your attorney, but have you really tested your attorney to check on these 10 things? If your attorney is not at an A level on all 10 of these, make no mistake about it, your opponent likely will be. It's important to double check on the attorneys and understand the 10 keys to victory for a litigator. John Belcher, law offices of John Belcher, 10 necessary items for clients to check on with their litigation attorneys.